For the record, this matter is before the court on the defense motion for child support. This hearing is being conducted via Zoom. President's Attorney Christine Hills, representing the moving party, Alicia Rupert Rami, and Attorney John Finn, representing the plaintiff, Fred Nitz IV. Good morning.
Good morning, Your Honor.
The parties have conferred with Mr. Walker from the front of the court, who has provided the court fine recommendation that commencing October 1st, 2024, the plaintiff, Fred Nitz IV, shall pay child support in the amount of $621 per month. Uninsured medical expenses shall be shared equally 50-50. This is based upon 290 overnights for the plaintiff and 75 overnights for the defendant. It shall be the other way around. The overnights, the 290 overnights, is that the defendant's overnights?
290 is the defendant. Yes, Mr. Nitz is.
I may have messed that up. I can submit a updated record.
Mr. Nitz is the plaintiff.
That's my mistake.
Thank you, Mr. Walker. Further, it's noted that the current support shall be $357 per month. Base support, $14 per month ordinary medical for the months of July, August, and September 2024. Is there currently uniform support order in place, Ms. Hills?
There is not.
Okay, so with this recommendation, you'll prepare an ordinary child support order and a reference 357 for the months of, I'm sorry, well, let's see.
371 for the months of July, August, and September. 357 base plus 14 ordinary medical.
And that'll increase to 621 commencing October 1st, 2024, correct?
That is correct. Mr. Nitz was on disability for a period of time, so we're accounting for that.
Thank you. Ms. Hills, is this recommendation agreeable with your client this morning?
Yes, it is, Your Honor.
Mr. Finn, is this recommendation agreeable with your client this morning?
I believe so, yes.
All right, do you want to voir dire? Is Ms. Rupert Rami present on audio this morning?
Yes, I'm here.
Okay, the parties are present. Counsel, do you wish to voir dire your respective clients regarding the recommendation? Obviously, they both participated this morning with Mr. Walker.
I do not need to, Your Honor.
I don't think I need to either.
Okay, and Ms. Hills, you'll prepare the uniform support order then, correct?
I will, and we also owe friend of the court a couple of forms as well to go along with that. I'll take care of that.
Thank you, Mr. Walker, for your assistance, and Ms. Hills and Mr. Finn. That will conclude this matter. The court will adopt the recommendation. Copy mailed out to counsel. All right, could you out have the rest of the day, Mr. Finn and Ms. Hills?
You too. Thank
Thank
you.
you.
Thank you.
The matter of Kelly Lavoie versus Nicholas Alexander.
21. For the record, this matter is before the court for the purpose of reviewing father's parenting time, particularly the continuation of SoberLink. This hearing is being conducted via Zoom. Present is Attorney Maria Zagorski, representing the plaintiff, Kelly Lavoie. Ms. Lavoie is present with Mr. Zagorski. In addition, Attorney Matthew Vitito is present, representing the defendant, Nicholas Alexander. Mr. Alexander appears to be present with Mr. Vitito. Good morning, everyone.
Good morning.
Court has received the fine recommendation from Ms. LaPrade. I thought she was on vacation this week. Okay. The recommendation from Ms. LaPrade is that the father may discontinue the use of SoberLink. However, the prohibition about alcohol consumption immediately preceding or during parenting time shall continue. There should be no alcohol consumption by either party before or during parenting time. Neither party shall transport the children after alcohol consumption. The parties shall split the cost of SoberLink device, the mother's portion being $446, which shall be credited toward child support arrearages. That is a recommendation. Mr. Gorski, is this recommendation good with your client this morning?
It is. Thank you, Judge.
Mr. Vitito, is this recommendation good with your client this morning?
It is not, Your Honor. Specifically, my client would object to the portion related to the reimbursement of the expenses. He believes that it should be 100% reimbursement and not the 1/2. And the basis for that is the April 18th order regarding those tests, which states, and I quote, "For a period of 4 months, defendant shall use SoberLink on his parenting time days and shall be tested for alcohol use at 6:30 a.m., 10:30 a.m., 2:30 p.m., 6:30 p.m., and 10:30 p.m. The cost of sober length initially shall be paid by defendant. If any results reflect alcohol use, defendant shall be solely responsible for costs associated with the use of sober link. If the results reflect no alcohol use, plaintiff shall reimburse defendant the cost of the use of sober link. The reimbursement may be deducted from defendant's child support obligation via 100% credit to him if appropriate. The determination of which shall be made at the review hearing as set forth below. And this
I'm sorry,
now
what's in this order, Mr. Vito? You're reading really quick and I'm trying to find the court order. What's the date of the order?
it was April 18th of this year. And it's page 2.
Okay.
And it's the second full paragraph on page 2, Your Honor.
Okay, I see what you're referring to. And so obviously what the total is about $900, is that correct? And is this 446 is one half?
Yeah, it's 892, Your Honor. Yes, that's the full amount.
Okay. All right, Mr. Gorski, your response to that? The language does seem to suggest that if the results reflect no alcohol use, plaintiff shall reimburse defendant for the cost of the sober link.
Yes, Judge. And you'll recall that the court adjourned this for 4 months, and we were back before Your Honor on August 6th. And at that time, it was determined that Mr. Alexander had only tested for 3 months instead of 4 because he put it off for a month. And then when we looked at the results, despite the order that you just reviewed being very clear, Mr. Alexander couldn't figure out what 6:30, 10:30, 2:30, 6:30, and 10:30 meant on his parenting time. And in fact, he was testing late and he was missing all of his Tuesday morning tests. No, I'm sorry, he was missing every Thursday morning test except for one. He knew he was supposed to test on Thursday because he tested once. He just didn't do it every Thursday. And he was missing some Tuesday mornings. And so we had to go back in with Ms. Patrick and we had to enter an order that set forth. It was a ridiculous order that apparently Mr. Alexander required because he didn't understand the order of April 18th. In great detail, Ms. Patrick had to set forth on every single day what time he had to test. My client incurred unnecessary attorney fees because of his noncompliance, and my client is here again today because of his noncompliance. We had to extend it another month, and we don't really know whether he was compliant for those first 3 months because he was missing tests all the time. And so I think it's appropriate and fair that they share the cost because he's not 100% compliant. I'll give you, after your warning last time that he'd be on time and within 5 minutes, for the last month he has been. But the first 3 months, he wasn't. And I could arguably assert that my client should only be responsible for the last month. But in the spirit of compromise, she agreed to split the cost.
Your Honor, I'd like to respond.
Please, Mr. Vito.
Your Honor, the confusion with my client's lack of testing arose, based on my understanding, is that when the order came down, he had contacted Ms. Zagorski to ask to clarify what days he was supposed to test on. And I don't know whether or not she was reading from the order, and I'm certainly not trying to blame her for that, but there was some miscommunication about what those days were. And I think she rightly notes that he had an obligation to review the order and follow the order and not what counsel warranted, but he was also without counsel at that time. And he saw her as an authority. And so he had contacted her to get the SoberLink contact information. And they had some email exchanges, I believe, where she had said that she believed that Jeff Finley was the person at probation who was the person that sets that up. And she was going to give him a few days to, get back with her or whatever. And so that few days stretched out to be approximately a month. But my client, once he had that information, immediately went and set that up. And there was a point where the SoberLink device was not working correctly, and he drove all the way out to Warren to have the device swapped out because he didn't want any further delays. So I think that he's made a good faith effort to comply. There was some miscommunication about what those dates should have been. Counsel's right that he should have followed the order. However, I think because he mistakenly saw her as, she is an authority figure, but she's not his attorney. But he saw her as this authority figure that could give him that clarified information. He wanted to make sure that he was blowing correctly and timely. It just, he was trying to do it in good faith. And so we're here again in good faith, showing that he hasn't had any positive results. And the language of the order says that if there are positive results, he's responsible. If there's not positive results, then she's responsible for it. And he's not asking her to take it out of pocket. It's just a credit to the arrears that are already on the record.
Briefly, Judge, A missed test is a positive test in the world of SoberLink, and to say it's just a credit, Mr. Alexander owes my client over $5,000 in child support. He hasn't paid a dime yet. And so to say it's just a credit, it's not real money isn't accurate. And that's all I have to say. Thank you.
And again, Mr. Gorski, I don't know if you've asked for attorney fees in the past. Obviously, this whole incident over the last 4 months would not be necessary, but for Mr. Alexander thinking he can ignore an order of this court. Court recalls very specifically, I know he did reimburse the cost of the private investigator, and he, notwithstanding his agreement in Judge versus alcohol consumption, he ignored that court order and actually was found to be consuming alcohol when the children were present with him, and he transported the children after having consumed some beers. I don't know if you asked for attorney fees throughout this. I mean, if in fact the court wants to, Mr. Alexander wants the court to follow the strict language of this order, we can address that $446 in attorney fees. I mean, Mr. Vito, it's not unreasonable.
Your Honor, he reimbursed the amount of the private investigator as the court ordered promptly.
Right, no question. I say that, but he never reimbursed Ms. Kosar for unnecessary attorney fees, and that brings matter before the court.
It was never ordered.
I understand, but there was order that he not consume alcohol, and he violated that prohibition in his judgment divorce.
I understand that, Your Honor, but now
there are 3 hearings now to address this issue. Ms. Kosar's unnecessary incurred fees. I'm just asking if Mr. Gorski, I don't know if you ever asked for attorney fees throughout this proceeding.
Judge, I didn't in my initial motion, apart from saying all additional relief in accordance with the children's best interest. Mr. Alexander wasn't paying child support. You're right. My client has been paying me to come to court repeatedly because of his violation of a consent order. And so again, I would say that the splitting the cost of the SoberLink is more than reasonable. He didn't hire an attorney. He didn't follow your order more than once. And we're here today because of his conduct.
Right. Mr. Vito, anything further?
I'm just asking the court to order what was, to follow the order as it was written. He didn't have any positive results. All of his results were negative. That is what would be fair.
Of course, this is a court of equity, and the court determines what's fair. Clearly, the black, clear language of this order does say that the plaintiff would pay 100% of it. But again, we wouldn't be here. And I think this is the third or fourth hearing regarding this issue. Ms. Gorski, prior to your involvement, Mr. Vito, Mr. Alexander has been before the court a number of times. If I recall, until he was confronted with documentation from a private investigator, I mean, he was going to ignore this court's order. So the court believes that the adoption of this recommendation is appropriate and reasonable, given the fact that Ms. Kosar has incurred significant more than $400 to $500 in attorney fees and haven't bring this matter to the court's attention. So on that basis, and being the court of equity, the court will adopt the recommendation, Mr. Brad, that the mother's half the costs. And the court acknowledges that the language of this order says should be 100%. But if in fact Mr. Gorski was asked for attorney fees, the court will be inclined to award that, Mr. Vito. So in lieu of coming back on for another hearing on attorney fees, the court will adopt the recommendation that the mother's share of $446 shall be credited against child support arrearages. And hopefully Mr. Alexander will comply strictly with this order in the future. All right, with that, the court will adopt the recommendation. Now conclude this hearing. Everyone can zoom out. Have a good rest of the day.
Thank you.
Welcome.
Thank you, Your Honor.
The record of this matter is before the court, and the defendant father's motion to modify parenting time and child support. This hearing is being conducted via Zoom. Present is Attorney David Sebastian, representing the defendant moving party, Andrew Peacock. Mr. Peacock is also present. In addition, Attorney Jennifer Peterson Ramsey is present, representing the plaintiff mother, Shaylee Peacock, and Ms. Peacock is present with Ms. Peterson Ramsey. Good morning, everyone.
Good morning.
Good morning, Your Honor.
The parties have conferred this morning with Ms. Patrick, our Monroe in front of the court. Please provide the court with a fine recommendation that the defendant's motion regarding parenting time be denied for the reason that there is not a sufficient change of circumstances. The issue of child support, was that addressed this morning?
It was not, Your Honor. I did have a conversation with Mr. Sebastian about the past recommendation that the front of the court had done, but since we were not modifying the parenting time, we did not really discuss changing the child support.
Okay. I don't know if the incomes have changed or when support was last scheduled. Mr. Sebastian, is support still an issue if the court adopts this recommendation?
Your Honor, the only issue, as I understand it,
if the court adopts the recommendation, is that the existing UCSO failed to account for a second family or defendant father, and that should have been accounted for, and the calculations would be affected thereby.
Okay. I suppose we can always refer the issue of child support to the front of the court for a formal investigation recommendation with an effective date of October 1st. Would that be acceptable?
Yes.
Right. Ms. Peterson Ramsey?
Yeah, I would just, if he does have an additional family, which I understand that he does, and if that was not included, then of course I don't have any objection. That recommendation just came out in April of this year and no objections were filed. So I think he missed the objection timeline, and that's why we're here today. But, obviously child support should be pursuant to the guidelines. And if he has a second family, we should look at that.
Again, I don't know when this child was born, if the child was born after that April modification or not.
Was not that his second family's been in existence. I don't know why he wasn't given credit for it. I wasn't part of that hearing.
Okay. Well, obviously that's Mr. Peacock's obligation to inform the front of the court of that situation. But in any event, with respect to parenting time, the court has read the pleadings and also the response of Mr. Sebastian to your motion, indicating that yes, even though there's a lot of people, mom's home, the boys have one room, the girls have one room, which is important to this court. Currently, dad's parenting time is week on, week off during the summer, but during the school year, it's just alternating weekends. Is that correct?
That's correct.
Was there also an issue about the school enrollment? The children are currently attend airport schools. And that are they currently enrolled in airport?
Yes, that's correct.
Okay, so they've not been changed. Dad lives in Wyandotte. All right, based upon the court reading the pleadings, Mr. Sebastian, the court's inclined to agree with Ms. Patrick that there does not appear to be a sufficient change in circumstances to modify parenting time at this time. Obviously, during the school year, we don't want to interrupt the activities of these 14 and 11-year-old children. Again, obviously, the allegation certainly raised the issue, but then the court reading the responses, that's sort of satisfied the court that there's not sufficient basis to modify parenting time, even though there's cats. Obviously, the fleas do not seem to be a significant issue. There's the issue of missing school. That's a significant issue, but Ms. Peacock, mother, has addressed that and provided copies of doctor reports, and that's appropriate that if children are missing school, they need to be seen by a doctor. That seems to address the issue of missing days of school. So answer, Mr. Sebastian, any else thing you want to add to your request this morning?
Yes, Your Honor. So subsequently to filing the motions, we received the notes from the minor child's therapist. And
I would just object to these notes because I have not been provided a copy of them. I don't even know if they exist. I don't know what he's looking at. So I would object to any reference to therapy notes that I haven't seen.
Mr. Sebastian, it's a good point. I mean, obviously, those should be forwarded to Ms. Peterson Ramsey so she can appropriately respond.
Your Honor, she could obtain the notes. She actually goes to the therapist. She could have obtained the notes the same way my client did. And unfortunately, it took him a while to get these notes so that I didn't have them when I filed the motion. But there's a number of issues raised that I think go to proper cause in support of the motion, all of which mother is aware of that she's denied in her response.
Well, I guess if you want, we can, if you want to adjourn this for 30 days, you can provide a copy of those reports to Ms. Peterson Ramsey so she can appropriately respond.
Your Honor, I mean, I would object to any adjournment. I think the motion has to be denied. This is a threshold hearing and Dad hasn't met the threshold requirement. As far as the missing school, the grades have improved. The children have been in therapy. Dad's just not involved in the children's life to know what's going on. And he's made these baseless allegations with nothing to substantiate them. I would ask the court today for an order preventing Dad from discussing legal matters with these kids. Dad showed the children his receipt for attorney fees that he paid his attorney, and the children are very upset about knowing legal matters. So I would ask the court for an order today preventing either party from discussing legal matters with the children, showing them receipts that they've paid attorneys. The children shouldn't be involved in any legal matters. And I believe Dad hasn't met. Today was the date and time for him to meet his threshold. He hasn't done that. And I would ask that the motion be dismissed.
Well, the court agrees wholeheartedly with you. And Mr. Patrick, the court will add that neither party shall discuss these proceedings with the minor children. That applies to both parties, Mr. Peacock, Ms. Peacock. The children are minors. They should not discuss these proceedings for any time with the children at all. So it's between the two of you and the court. So the court will add that to any order that neither party shall discuss these proceedings with the minor children or in their presence. All right, Mr. Sebastian, anything further? The court to agree. I mean, you apparently just received the reports. If in fact you believe there's a basis, you can file another motion. But based upon what the court has reviewed to date and the argument heard, the court is inclined to adopt this recommendation. So is there anything further than Mr. Sebastian?
Well, I would ask the court suggested adjourning the hearing for 30 days. I think that would be wise as opposed to having to just refile the motion. I mean, many of the statements in the response to the motion made by mother were knowingly false because we have now the therapist reports. Mom is aware of the issues that the daughter is undergoing, including issues of self-harm, snapping her wrists, telling her mother that she wants more time to be with her father. Please stop cutting me off. So, Your Honor, there's a number of issues that mom is aware of because I know from the notes, the therapist is discussing it with mom. This may actually be mom's therapist. I think there's family therapy that's going on as well. So mom's aware of this. She could have had access to this notes easier than it took us. We were able to get the notes and we weren't able to get the notes until after we filed the motion, or else we would have included a lot of this in the motion as well.
Mr. Sebastian, you could have easily emailed me any alleged therapy notes that you're telling the court that you have today. Today was the date and time for you to meet your threshold requirement, and you haven't met that today.
Which parent transports the children to their therapy? Are both children in therapy?
Yes, they are, and they have been for years. This isn't a change in circumstance. Dad is just not involved. Mom transports the children. So does mom communicate then with the therapist? Is she aware of the concerns? And is she addressing those concerns? Yes, she is. And we would deny that their concerns are evident, are there. And I think the grades reflect that. If these kids were self-harming, their grades wouldn't be as good as they are.
Judge, just in May, the school added extra appointments for the child, involved extra school personnel. And to say when she's failing drama and getting a D in fitness, that if she moves it to a C+, that's an improvement, I suppose is true, but it's still clearly a problem. On top of all the absences.
To that. Those grades are not accurate. She's gone in math. She's gone from a D+ to a C+. In English, she's gone from a C- to a B. In science, she's gone from a C+ to a B. And I'm not just going off what my client says. I've obtained the grades.
We have them too.
Okay, I don't know what middle of the school marking periods.
Brother, so the central question is mom addressing the concerns of the therapists?
Absolutely, she is. And she's been taking the kids to therapy for years. She's taking care of their mental health needs. Your Honor, the court should be aware that in April of this year, the friend of the court doubled Dad's child support. That's really why we're here today. He didn't file objections to that child support recommendation. And that's why we're here today. And if you look at the procedural history of this case, every time the friend of the court has increased his child support, we're here on a motion. So the kids have obviously been doing fine all these years, but since the friend of the court doubled his child support, now they're not doing so good.
Your Honor, this goes to the fact that representation is totally false, and mom knows it, because on July 30th, the daughter told her mother with the therapist that she was unhappy at her mother's, that she wanted to spend more time with her father, that the mother's house was too crowded, there were too many pets, that was dirty. She was depressed, had poor concentration, decreased motivation.
Object to this. This is
So,
not true.
All of this was told to the mother per the
This is
note.
hearsay
There was
and
nothing to do with child support.
this is an
This is a
attorney
red herring
testifying.
argument.
The court agreed it's hearsay, but obviously Ms. Peacock needs to talk with that therapist and then address these concerns of the children. So if they're not being addressed, then yes, the court would take action. But at this point in time, with that direction to mother, the court will adopt the recommendation of Ms. Patrick with one addition that the court will refer the issue of child support to the friendly court for an updated investigation recommendation due to the fact that Mr. Peacock now has another child involved. That may affect the amount of child support somewhat, but otherwise the court's going to deny the motion to modify parenting time at this time based upon the information that the court has in front of it. If in fact, Mr. Sebastian, Mr. Peacock, if Ms. Peacock is not addressing these concerns or anybody as a therapist, by all means, bring it back before the court.
Okay.
Thank you, Your Honor.
Ms. Peacock will properly address these issues for the welfare, best interest of those children. Now, obviously, this keeping them healthy, getting them to school every day is critical, Ms. Peacock.
Yes, Your Honor.
The court had mentioned a commence date for the review. Could you repeat that commence date, please?
No, we're just, any modification of child support shall be effective October 1st. So we'll refer the issue of child support in front of the court formal investigation recommendation. Each side has 21 days which to object, and the commencement date would be October 1st of 2024.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Right, with that will conclude this matter. A copy of this order will be mailed to council. Now we'll conclude this matter, and we're going to zoom out. Have a good rest of the day.
Thank
Thank
you.
you, Your Honor.
Welcome.
Adam Opperman.
Is Adam Opperman present?
Yes, I am.
Okay, Mr. Opperman is present on audio. Sir, could you please state your name and current mailing address for the record?
Yeah, my name's Adam Offerman.
Thank you. For the record, Mr. Opperman is appearing this morning via Zoom at the request of the Monroe County Friendly Court Attorney Rebecca Hicks, who's also present. And Ms. Hicks, can you provide the court with some information regarding these two cases, please?
Certainly, Your Honor. The 2012 case with Amy Hopper on the other side has a current monthly support obligation of $466 per month. The current arrears balance is $7,223.17. A payment was last made in October of 2023. The 2019 case with Lauren Fugate on the other side has a current support obligation of $450 per month. It has a current arrears balance of $6,574.97. And again, the last payment was made in October of 2023. This hearing ended up on the docket today after being elevated from the previous hearing with referee McKee in August. There had been four referee hearings with adjournments since the last payment was made before the referee finally elevated it to this docket for finding of contempt. And at this time, that's what the front of the court is requesting.
All right, so Mr. Opperman, do you understand you're being charged with civil contempt of court for failure to exercise due diligence with respect to your child support obligation? If convicted, you could be ordered to serve up to 45 days in jail. Since there's a real possibility of jail, you have the right to an attorney. If you're unable to afford an attorney, the court will appoint an attorney to represent you at public expense. Do you understand all that, sir?
Yes.
Are you requesting a court-appointed attorney?
Yes, I am.
Okay. Okay, I just need to ask you a couple questions to make sure you're qualified. Are you currently employed?
As of last week, yes.
Okay, with whom?
Fast Track Trucking.
Where's Fast Track Trucking located?
It's down in Toledo, Ohio.
Okay. Are you over-the-road truck driver or is it local?
I am local.
So you've been there, employed by a Fast Track Truck for what, 1 week?
Yeah, so my official start date was last Monday.
Okay. You don't know, you get paid every week or every 2 weeks?
Every 2 weeks.
Any idea your income, your take home every 2 weeks?
Not yet. I'm going to be making 50 cents a mile plus $15 an hour stop time.
Okay. Do you have any other income?
I do not.
Do you own any property of any value? Like, do you own a home?
No.
Bank accounts?
I do have one bank account.
Approximate balance?
Probably about $240.
Any boats, snowmobiles?
No, sir.
So have you been unemployed since your last pay in October of 2023?
No, I own my own trucking company that was losing money severely.
Okay. Did you sell your truck?
I am in the process of trying to sell the truck and trailer.
Okay, so you're with this Fast Track Trucking, will you be an owner operator or you'll be using one of their trucks?
I'm using their trucks.
All right, so obviously you, how much is your truck worth?
In this current market, I'm hoping to get around 20,000.
Is it on the market?
Yes.
Okay, you might need to reduce that price, Mr. Opperman, to come up and take care of these rearages.
Okay.
About 14,000 rearages, so I think you need to reduce that price. So to move that truck, I don't know how long it's been on the market, but anyway, the court will grant your request for court-appointed attorney. Do you drive every day, Mr. Opperman?
5 days a week, Monday through Friday.
Okay, but are you driving today?
Yeah, I'm currently at a truck stop.
Okay, so what are your hours of driving typically?
I've been averaging between 10 and 14 hours.
Okay. How long's your truck been for sale?
So the truck has only been sale for about a week. The trailer has been for sale for 2 to 3 weeks.
Do you have any prospects, offers?
So I do have one prospect, but no current offers. The trucking market is just terrible right now. Nobody really wants to spend money in the industry.
Well, you may want to reach out to that prospect because you need to come up with some quick cash in order to avoid a jail sentence, Mr. Opperman. When you get elevated to the court, that means you're getting really close to serving time in jail. And I'd rather see you continue to work rather than spend time in jail because I don't want to see you lose this job, but it's a real distinct possibility unless you can borrow some money from family and friends or turn over that truck real quickly. In any event, the court will grant your request for court attorney. Mr. Opperman, I'm going to have you personally appear later this week. And again, if in fact you think you can come up with I want to give you some time to come up with some money because that's what I would think that's going to avoid you going to jail later this week.
Okay, yeah, I mean, if I go to jail, what's that?
I'm asking Ms. Hicks what day she would suggest, and I understand going to jail, Mr. Opperman, but this one has been going on since October of 2023. There's not been any payments made in almost a year. Simply unacceptable.
We can give him till Friday, Your Honor.
All right. All right. I'm going to, rather than have you come in tomorrow, I'm going to have you come in on Friday. That is September 13th. You are to personally appear Lab 15, September 13th. Mr. Opperman, that's Friday this week. Personally appeared Judge Braunlich's courtroom on the 4th floor of the courthouse. Give me a cell number because I'll have the court-appointed attorney reach out and to talk to you. So give me your cell number that he can contact you between now and then.
Yeah.
Okay, Mr. Opperman, you appear on Friday, September 13th, 2024, Lab 15 a.m. personally. And Ms. Hicks, what's an appropriate amount that you believe Mr. Opperman should bring in with him on Friday?
I would say
1,500 be sufficient?
How much, Your Honor?
1,500?
Sure, Your Honor, that will be sufficient.
All right, so Mr. Opperman, you need to personally appear Lab 15 outside Bronx Court Friday, September 13th of this week. And the court's going to suggest you reach out to my friends, come up with $1,500 to pay toward your child support in cash that morning, because in that case, the court would not impose immediate jail. If you can't come up with that, there's a good chance you go to jail. So bring it either $1,500 or bring a toothbrush, Mr. Opperman. The attorney will talk to you between now and then. Any questions?
Not at this time.
So please reach out to family and friends. That's going to apply toward your rearages, not going to attorney fees, your costs, 100% your rearages. But that's it will give this court an impetus not to impose immediate jail. So reach out to family and friends. You can pay them back once you sell this truck.
Okay.
Total $1,000 total. Can you make that payment to the front of the court when you come in on Friday? Any other questions, sir?
Not at this time.
Okay, we'll see you on Friday then, September 13th, 11:15.
All right, thank you.
For the record,
Thank
this
you, Your
matter
Honor.
is before
I'll
the
upload
court
those
for the
orders
purpose of
shortly.
reviewing plaintiff father's parenting time. This hearing is being conducted via Zoom. Present is Attorney David Carson, representing the plaintiff father, William McLaughlin. Ms. McLaughlin is present. In addition, Attorney Kimberly Kuhn is present, representing defendant mother, Misty McLaughlin. Ms. McLaughlin is present with Ms. Kuhn. Good morning, everyone.
Good morning.
Court is aware of the history of this case. The parties have met with Ms. Pratt this morning from the front of the court, who has provided the court with fine recommendations that the two children of the parties, the name of the boy, shall continue counseling with Mark Haskins, with whom they've been involved in counseling for a period of time. Father shall continue counseling with his counselor, and the counselor shall advise the parties as to a reunification counselor. The parties shall communicate with each other via app close regarding the children only and in a respectful fashion. And all appointments for the children shall be placed and added to the calendar on app close. That is a recommendation. Mr. Carson, is this recommendation go with your client this morning?
No, Your Honor.
I'm sorry?
No, Your Honor.
What do you say?
No. Can you hear me?
Sorry.
Okay, yeah. But you're breaking up. Can you repeat your
sorry.
response?
No, Your Honor.
Okay. All right, Ms. Kuhn, your client's position?
My client is in agreement with the recommendation. Mark Haskins works with these high conflict cases. He has expressed a willingness to work with the boys. He knows that reunification is the goal. I believe he feels that father needs to work on issues with his individual counselor. He said he can work with the boys on their issues. And then if both counselors if releases are signed and both counselors are working together to address concerns that each needs to work with their clients, they're going to be in the best position to find a reunification counselor for this family. We've tried and we've tried and we've tried. So I just think that, especially in light of Mark Haskins' opinion that dad needs to continue with his therapy, the boys need to be in therapy, dad needs to deal with anger management. Obviously, the boys have a lot of issues too. I feel like this is really going to be the only and our best course moving forward. We're allowing the counselors to help put in place a third counselor, and these counselors are going to know all of the positives and the negatives of the clients that they're seeing and what's going to work best. So I think it gives us the best chance for success if we do it this way. So my client is in agreement for those reasons.
Well, yeah,
And the boys do like Mark Haskins. The boys really like Mark Haskins. They really did. My client said that they really felt comfortable talking to them. We have to remember that these boys have been to so many counselors that a lot of times they just shut down with counselors. The boys liked Mark Haskins. That is half the battle.
Right, thank you, Ms. Kuhn. The court has been continuous for a review for a number of months now. I mean, the court says there's not more progress. I thought we've been talking about reunification counseling for some number of months.
Yes, Your Honor. And if I could briefly just make a statement, Your Honor. Your Honor, like the court already said, we've been dealing with counselors for a long time in this case. The children were seeing counselors at the Family Shelter Counseling Center, and they were discharged from the Family Counseling Center, and they were recommended to go to reunification therapy. So it feels like we're taking a step back now, and we're going to go to individualized therapy again. And what I was proposing is that we appoint a new reunification therapist, either Dr. Richard Wooten or Toby Beach. I understand that they are not close to mom, but however, I believe that the children's relationship with dad should be paramount here and should be important. Also, Your Honor, I just think that we're wasting time here. I think we need to make progress, and going back to individualized therapy, waiting another 8 weeks, and then finding another reunification counselor is just going to take more time. Like I was saying in the prior room, these kids are older. They're going to be 18 in a few short years, and the court's going to not have any jurisdiction over them. So if we're going to save dad's relationship with the kids, we have to do something now. We can't sit back anymore.
Your
Have you
Honor,
provided to Ms. Kuhn the names of those reunification counselors?
Yes, Your Honor, but first, let me just respond, Your Honor, because I think it's important that you know this. The parties did try reunification counseling with Mark Haskins. He met with all of the parties. He met with mom, he met with dad, he met with the kids, he met with dad and the kids. And Mark Haskins said, hey, whoa, this is not good. If the kids are pushed right now, there's going to be no progress. So his recommendation was that the boys work with the counselor, and he was willing to work with them. Dad work with his counselor with a focus on anger management and move forward that way. And when we were talking to Ms. LaPrade, we were discussing that if the counselors are doing that, they're going to be in the best position to find the reunification counselor. Your Honor, you know, with Dr. Wooten, we've been waiting a year and 2 months now for a report on a case that we have before you. I know also that we've had to delay another case on a case that I have before you because Dr. Wooten has been just swamped. My client also is not working, does not receive child support right now. There's about $7,000 in arrearages. She has 28 miles to get home today. I'm giving her gas money, Your Honor. She's not going to be able to get to Dr. Wooten. And it doesn't make sense right now because Dr. Haskins has clearly said these boys aren't ready. They need counseling. And Dr. Haskins, as you know, Your Honor, he works with a lot of our high conflict cases. He's going to hold everybody accountable, and he's already held the parents accountable. He's already said these two are angry. These two need to stop. And dad needs to focus on this, and he's willing to counsel the boys. So I would like to give Dr. Haskins a chance with dad's counselor. I believe he goes to, is it a Tree by the Sea? And he's seen a counselor there. It would make sense for those counselors to work together and try to figure out how to work.
Why do you court order to communicate? Why can't someone reach out to Mr. Haskins and dad's counselor and have the two counselors talk to each other?
I think they need to sign releases. I think that's the problem. I think that the counselors, I think the parties, as long as dad signs a release for his counselor to talk to Haskins and signs a release for Haskins, I think as long as the parties sign releases, then we're good.
Okay.
And Your Honor, I'm sorry.
Can the parties do that, sign releases so that two counselors can talk?
Yes. Today, I'll have my client do that.
Mr. Carson, any reason why Mr. McLaughlin's counselor would not sign a release?
I have not spoken with this counselor, but I don't think that'd be a problem, Your Honor.
Okay, well, let's do that. And if we're gonna put this over for a couple of weeks, the court will keep it on docket. The court wants nothing more than to reunify dad with these boys, but we need to move on this. And if we need to have the two counselors talk and recommend a reunification counselor, and that's convenient for both parties, then let's do that. Can we do that if come back in 2 weeks?
2 weeks? Sure.
Yes.
All right, so Ms. LaPrade, if you can adopt modify the recommendation, the party shall sign a release allowing their counselor to talk with Mr. Haskins and vice versa. Mom sign a release allowing Mr. Haskins to talk with Mr. McLaughlin's counselor, and let's get those releases signed as soon as possible. The counselors can talk. Do you think we can make some progress in 2 weeks and have hopefully agree upon a counselor, a reunification counselor?
I hope so, Your Honor.
My client will sign releases immediately.
Okay, can we put this off for 2 weeks? 24th and 25th.
9/24.
How about September 24th at 2 o'clock? Is everyone available?
Yeah.
Your Honor, could we do a little bit earlier, like at 1:30? I have nobody to pick them up. They get out at 2:48 in Wyandotte.
We can do 1:45. That's the sooner we have 1:30 already, Ms. Kuhn. We could do 1:45.
That's fine.
It sounds like the kids go to school out of district and mom has to pick them up. So they're going to be, she has to be, where do you wind out at 3? By 3, yeah. She has to be wind up by 3. Is there anything in the morning, Your Honor, or is your docket full?
It's full. How about the 25th then?
25th, the only thing we have open is 2:30 and 3.
2:30 or 3 on the 25th.
We have the same problem. Yeah.
2:30 is fine, Your Honor.
We are booked.
Can I have you just appear? You might have to just.
What about Monday the 23rd?
What do I do with them? Make them stand outside the car because they don't need to hear it. Yeah.
What, 9:45 on the 24th, Ms. Kuhn?
9:45 on the 24th. That works.
9:45.
You can do that. 9:45. That works, Your Honor.
That works for me. Yes.
All right, Mrs. LaPrade, we can put the court review this matter. That's September 24th. That's 2 weeks from today. 9:45. We'll squeeze it in, a quarter of an hour. So that the court's supposed to make some progress. So we have identified, and hopefully we can agree upon a reunification counselor. If not, the court will pick one. So if you can't agree, please communicate and get those releases signed to ASAP. If you cannot agree upon a counselor, then you submit your recommendations and the court will make a decision when you come back in 2 weeks.
Understood. Thank you.
Thank you.
So otherwise, court will order the boys should continue counseling with Mr. Haskins. Mr. McLaughlin will continue his counselor, and let's get that recommendation as soon as possible. And we'll see everyone back here September 24th, then at 9:45.
Perfect. Thank you, Judge.
Have a good day.
You're welcome. That will conclude this matter. Thank you, Mr. Okay, I need to see what's it about.
There's a renotice in the McLaughlin file for today at 9:45, so
Okay,
somebody's gonna take it and talk to them.
do we have the file?
Yeah.
Okay. Why is it not in our docket?
I can have an email that I will put you on doc for 10:15 at 10 a.m. I don't. Just all folder.
Says, motion to compel October 15th. Oh, we'll be down about September 24th. Okay. This was filed September 12th.
I don't have anything.
Of September 10th, said it was adjourned to September 24th, 9:45. So we're on the record September 10th. I entered an order. It may be adjourned to September 24th.
Yeah, September. Yeah, September 9th.
September 10th, we were in court. The order said to adjourn September 24th.
You want me to get Mr. McLaughlin and his attorney out?
Call that 3:30.
No, you're fine.
So, yeah, I gotta see what's going on. Let's see, the order's right in the top right here. It says September 24th. Find that document, September 10th, to find out what's going on with it.
Hey, Jason, what's your client's email? I'm doing the up close invite right now.
Give me half a second to pull that up. Let me see.
Thank you so much.
Yep, no problem.
What?
No, I'll just stop.
Stop. I don't want. So his email is.
Hey, Jason, can you ask his girlfriend to not be with him? I mean, that's ridiculous. I don't have anybody here with me. His girlfriend shouldn't be telling you that you can't give me his email to send him an app close invite. Mr. McLaughlin's girlfriend's right next to him.
Breakout room. They can argue in the breakout room.
Are you ready?
I was trying to get a app. Yeah, we're ready. I'm just trying to get.
We're ready. We can table the issue that we're currently arguing with, and I can solve that after the fact.
Please, judge is ready.
For the record, this is before the court, I believe, for reviewing plaintiff father's parenting time. This hearing is being conducted via Zoom. Present is attorney Jason Tower, representing the plaintiff father, William McLaughlin. Mr. McLaughlin is present. In addition, attorney Kimberly Kuhn is present, representing defendant mother, Mr. McLaughlin. And Ms. McLaughlin is present with Ms. Kuhn. Mr. McLaughlin, I apologize when you zoomed in earlier. This did not make it on the court's docket. So in any event, parties have conferred with the front of the court. One moment, I'll share the recommendation. The front of the court has recommended this matter be adjourned to November 12th at 9 a.m. Presumably, minor child is still counseling with Mr. Haskins. Is that still ongoing?
Yes, Your Honor. It is. It's my understanding that the counselors needed additional time to be able to pick a reunification counselor. The 2-week time period was not enough time. So that's why we're asking, and that's why Ms. LaPrade made the recommendation to move the date to November so that we could come back with a selection by the counselors. If the court remembers, the counselors would advise the parties as to the reunification counselor. Both counselors did speak. So that's what's going on right now.
Yeah,
right, so
that is accurate. However,
I'm sorry, go ahead, Mr. Tower.
Yeah, I was going to say that is accurate. However, my client's problem with this is kicking it out another 2 months. My client has been trying to reunify with these children for over 14 months now, and kicking it out an additional 2 months is frankly a little bit ridiculous here. I understand that the counselors did meet. However, they are indicating that 2 weeks was not enough time for them to be able to pick a third party. My client is wanting to move on this as quickly as possible so we can actually start seeing the children start developing a relationship with them. The children are 14 and 16. So very quickly, this court's going to lose jurisdiction over at least one of them, if not both of them. And my client will not have been able to reunify with them. So this time we're actually proposing another specialist in my client's therapist's office, not the same therapist that he's seeing, but an entirely different one by the name of Alicia Lieto. He would like to use her. She's only a mile away from mom's house. It's very close, takes her insurance, it would be covered.
So the children will talk to Mr. Haskins, you're just asking for an additional therapist?
So Dr.
We're
Haskins,
asking instead of to have
Hold
the
on,
two
just a minute,
specialists-
Ms. Kuhn.
Sure.
Mr. Tower, are you asking this would supplement to the Children's Council with Mr. Haskins?
We're asking that this individual would actually serve as a reunification specialist. So my client would continue seeing his specialist, the children could continue seeing Mr. Haskins, and the reunification specialist would be this third one. Obviously, the therapists have met, but they've not picked someone. And how 2 weeks is not enough time for them to just pick a name, I don't understand. So we're picking a name. We've proposed multiple names. This one's the closest one.
I guess what's concerning to me is that we agreed last time that the counselors know the parties and the counselors would be in the best position to choose a reunification therapist that has the best chance of working with both dad and the children. If Mr. McLaughlin wants to just pull a name out of his hat and we fail miserably again, that just seems like a waste. It would make more sense to let the counselors who are working with the parties determine who the best counselor is going to be. And that's what we agreed to do last time. My client would like the counselors to have that opportunity.
Well,
that's not taking place.
Perhaps, hold on, perhaps this name of this individual, suggested Mr. Tower, should be presented to the therapist.
Sure.
Your Honor,
that person.
Your Honor, my client's therapist is the one who proposed that individual. She works in his office.
Okay, what's Mr. Haskins' response?
He just did this last night. Mr. McLaughlin said that he just got a therapist last night, a name. So I don't even think Mr. Haskins has even heard of the person. So if Mr. McLaughlin wants to provide that name to Mr. Haskins, let Mr. Haskins look at that and let him figure out if that's going to work. I mean, we're not opposed if that's one that Mr. Haskins thinks will work, and not a problem. But I mean, this is a last minute thing from Mr. McLaughlin that we just found out today.
Well, it's good. Some communication in the interim would be helpful. I mean, again, this is being presented to the court at the last minute, and you want a hearing date tomorrow, Mr. Tower. I mean, obviously, Mr. McLaughlin needs to suggest these things to Mr. Haskins.
Well, Your Honor, the issue with that is, according to the last order, the parties are supposed to download and use AppClose. Mom hasn't done it.
She has.
Hold on, I'm getting to other issues. Okay, is there a motion for show cause if mom is not complying with AppClose? Ms. Kuhn, please instruct your client to, and all communication be via AppClose.
Your Honor, if I may, my client has AppClose. I'm looking at it right now. Mr. McLaughlin will not provide an email address for my client to send the AppClose invite. And I just checked her AppClose, and she has not received an invite from Mr. McLaughlin. So that's the problem. I'm looking at her AppClose right now. I have her phone. So if Mr. McLaughlin can kindly provide me with an email, I will do it right now on the record and send him an invite.
All right, Mr. McLaughlin, can you provide an email address?
Yes.
Go ahead.
Sorry, I'm ready.
Communicatingwill.com.
Is it all spelled COMMUNICATINGWITH@gmail.com? Okay, doing it right now. That's fine. I'm sorry. That's fine. You want me to type it? It's locked up. Wait. Let's start. We will get that to him right now. Perfect. Thank you. Is it?
Okay, Ms. Kuhn, you also noticed up for hearing a motion to compel this morning.
At gmail.com. Yes, Your Honor. I sent discovery out to get the information regarding the vehicles because there had been in the judgment of divorce, the vehicles were to have been sold.
Was that discussed with the front of the court this morning, your motion to compel?
My motion to compel is actually, it looks like it's up for October 15th. So I can talk to the front of the court about it today, Your Honor.
Okay, we're gonna have it. Let's address that today. So we're not coming back every couple of weeks.
Sure.
And also, please address, I think you spoke to Mr. Pratt, who's going to communicate to Mr. Haskins the name of this reunification counselor suggested by Mr. Tower. Let's get that person's name in the order here. And then Mr. McLaughlin, or someone's going to communicate that to Mr. Haskins. If we need move up the hearing date, we can move it up.
Mr. Tower, can you give
time in
him,
October? So I'm going to have a
give
talk with Mr. Pratt once again. Let's address as many issues as we can this morning. Stephanie's still available.
Ms. Kuhn, you had a question?
yes, can you give Mr. Haskins the name of that counselor?
Yes, I can reach out to them.
Okay, perfect. The invite was sent. Okay, and the invite was sent.
All right.
Yeah.
What is this, man? For the record, this matter is before the court for the purpose of reviewing the plaintiff father's parenting time. This hearing is being conducted via Zoom. Present is Attorney David Carson, representing the plaintiff father, William McLaughlin. Ms. McLaughlin is present. In addition, Attorney Timothy Churchill is present, representing the defendant, mother Misty McLaughlin. Is Ms. McLaughlin, are you present on audio, Ms. McLaughlin?
Yes, she is present, Your Honor.
Right, she's present with Mr. Churchill. All right, good morning, everyone.
Good morning. Morning, Judge.
The parties have conferred this morning with the front of the court, specifically Mr. Walker, who has provided the court the following recommendation. I don't know if the court can order Mr. Haskins to do anything. The recommendation of Mr. Haskins shall provide a list of reunification counselors that he approves of within the 14 days to the attorneys. I know that was supposed to have been done previously, but the court can't order Mr. Haskins to do anything.
Yes, Your Honor, we understand that, and we're just going to seek Mr. Haskins' advice. And if Mr. Haskins does not want to provide us with names, the attorneys are going to choose a therapist, Your Honor.
To Mr. Haskins.
Excuse me?
Who will reach out to Mr. Haskins? Which Mr. Churchill or Mr. Carson? Who will reach out to Mr. Haskins to initiate that inquiry or that request?
I believe it was going to be mother in the case, Your Honor.
Mr. Churchill, is that correct? Ms. McLaughlin will reach out to Mr. Haskins?
She can, Your Honor. She's already done that. And as we told Mr. Walker, his whole opinion right now is, given the boy's age and forcing them to have contact, the forcing them would probably do more harm than good at this point. He's establishing a relationship now. Mom feels that the kids have some trust with Mr. Haskins. They're starting to open up to him. And if we just force this process, it's going to be more destructive than helpful. I can't say I totally agree with the rec, but I think we need to give Mr. Haskins a little bit more time with these kids. That's what he's asking for. He's been seeing them weekly and regularly, and it's taken a little while to build a relationship with them. He's only been seeing them since beginning of August, end of July. And these kids have had 7 therapists before. I mean, they've been through the mill of therapists, and I think Mr. Haskins is finally starting to get somewhere with them, and the other side doesn't think it's quick enough, so they're ready to jump ship or get other recommendations. And I think we should give Mr. Haskins more time to see what he can come up with. That's my opinion on it.
Well, Your Honor, I thought that we had an agreement here, but I guess that's not the case. So this has been going on, as you know, for over a year. My client has not had a parenting time in over a year. There was supposed to be a dinner last Christmas that didn't occur. We've been through therapists. We've attempted to pick therapists, and there's been arguments about that. It's been going on way too long. These children are older. They're 14 and 16. All my client wants to do is have some type of reunification therapy with his children. That is all he is asking. And all we're asking now, I guess, is to choose a new reunification therapist.
Well, the court agrees, Ms. Carson. It's been my docket since February this year. The party's coming back every 30 days or 45 days. I mean, we need to move on this. We're getting no further ahead. So maybe we need to, that was the court's recollection for the last time we were here. The parties were going to sign releases to allow the 2 counselors to speak. It says the Churchill 2 counselor Mark Haskins, father will continue his counseling. Did Mr. Haskins speak with Mr. McLaughlin's counselor?
Yes. He spoke with the lady that was recommended in the order too, and did not deem that she would be appropriate. The order said that they were to speak with the counselors to, just a second here, Your Honor, I'm grabbing the order.
Alicia told me Dr. Haskins that
Yeah.
Didn't want to do it because he recommended that the boys weren't ready.
And what it
Right,
said was,
I can't
we shall
hear.
engage with
Right.
Miss Alito, provided
Maybe
he
talk
had-
with Mr. I couldn't hear Miss McLaughlin at all, what she said, Mr. Churchill. So can you repeat what she said?
Yes, she said that Mr. Haskins spoke with Miss Alito, the one that was where it said in the order, parties shall engage in reunification counseling with Alicia Alito, provided Mr. Haskins has no objection. He did speak with Miss Alito and did not feel she was appropriate for that, and asked for more time. He did a report on November 7th, which I provided. We had a copy of it. I gave it to the front of the court and opposing counsel, where basically it says right now, the boys are still adamant about a relationship. Given their ages, forcing them at this time would probably do more harm than good. So we're asking a little more time for him to continue working with the kids before we get into the reunification counseling. And he also said he may be willing to do that, but at this point in time, he feels it's premature given the nature of the adverse relationship the kids have with their father. We're dealing with years of abuse that they're trying to undo here, and it's not going to happen overnight.
And Your Honor, I'd like to say that my client denies any abuse ever took place. And as I said, the court already knows the history of this case. We've been through this 100 times already. My client just wants to try to save some type of a relationship with his children. And we're just asking for a new therapist. And Mr. Haskins is not here. I spoke with Mr. Haskins yesterday, and he told me, I guess, somewhat of the same things. He did say that mom needs to try and foster a relationship between the children and father, which has not been done. And he said that it seems like a foreign concept to mom. But I did not hear that Mr. Haskins spoke with Miss.
That's not what he told her
at all. Excuse me, you can interrupt me. What do you think? Yes,
my client said that's not what he told
Ms.
her.
McLaughlin, Ms. McLaughlin, do not interrupt, please. Mr. Carson, go ahead.
Yeah, Your Honor. All we're asking for is just a new therapist. We just want to try this out. We understand they're older. We want to see if we can save some type of relationship. That's all we're asking for.
So what do you suggest, Mr. Carson? I get the court wants nothing more than that. And yes, I agree. Both parties need to make this work. Mom needs to encourage and foster relationship between the boys and their father. These boys are not infants. They're 14 and 16-year-olds or teenagers. So what's your suggestion, Mr. Carson?
Well, Your Honor, my suggestion is that we pick a new therapist. I'm in Troy. I'm an Oakland County attorney. I'm not familiar with the Monroe County therapist. Well, I guess I somewhat am, but the therapist that we've used, Mark Haskins, is not going to be the therapist here. So I would propose that we use, Dr. Richard Wooten. He's well known in Oakland County, and I understand that it's a far drive, but I'm running out of people to use in Monroe County, Your Honor.
Well, you're suggesting that we replace Haskins?
Well, no. I'm saying that we appoint a new therapist for reunification therapy, Your Honor.
All right. Mr. Church, any objection to Mr. Wooten? Obviously, we were spinning wheels right now. If Mr. Haskins won't provide a name.
He's very expensive, number one. And number two, he won't even cough up any of the money he got when he sold the cars. And we don't think I don't know how we're going to pay.
These guys are spending a lot of money right now coming back to court every month.
Okay. I think adding another counselor or therapist and forcing the kids to see a second person now is going to be more destructive than helpful. I think given the nature of the history of the relationship, the issues, the history of abuse, it's going to take any counselor a while to make any progress. And Mr. Haskins has only seen them for about 3 months. He feels he's making progress and headway with them. He just said at this time, it's going to be more harmful than helpful to force the reunification counseling. He's getting a trust relationship built up with the kids. I say let him try it another month or two, and if not, maybe then we look into someone else. But these kids have seen 3 counselors prior to him, 7 therapists. We finally got one that's starting to get somewhere, and it's going to take a while.
And Your Honor, I'd just like to say that I spoke with Dr. Haskins after the last hearing in September. He told me the exact same thing, that he needs more time and just wait 30 days and he'll see where we're at. And I guess he's made no progress then, because he told me the exact same thing about almost 2 months ago now. So,
well, he said he's making progress in this report you've got. Said he's establishing and he told the mother the kids have a real trust relationship with him now, which took a while to develop. You want to throw him in with somebody new out of town and
No, the court's not inclined to replace Mr. Haskins, and the children will continue to see Mr. Haskins. What about father of contact with the children, with therapeutic or family counseling shelters? Just observe the interaction between dad and the boys.
We've been.
Any
through
objection to
every
that?
There's
they've
no
been
lot-
through every counselor there, and because he cussed the last one out, they don't want to see him there anymore.
He wasn't even.
They were kicked out because of your behaviors.
I can't speak to that, Your Honor. This is the first time I'm hearing about this, so.
He's attorney number 5, so he probably doesn't know the history.
3.
How long ago was that?
It was the summer, of I believe.
The beginning of spring, there's 2 recommendations. You look back, Tanya and Miss Pizzo. One said, I can't give a recommendation right now because I don't really think he's ready. And the other one said, they're not ready. William called him because he still got the legal side of it. He switched them and they said there's no one left. So then we ended up in court again with Mark. And so this is the 7th therapist altogether. This is the 3rd, including Mr. Haskins, that said they are not ready. There's a lot of pent up stuff that he said I hadn't even told them. When we did our
Mr. Haskins. All right.
Sorry,
Well, thank you, Ms. McLaughlin. Maybe the boys need to see Mr. Haskins every week or every 2 weeks, rather than every month.
Every
or 6
week they're
weeks.
seeing him. It's
Every
weekly.
Okay.
This is the first time they've been in a counselor every week. Family Shelter Services, we're only wanting to see them once a month. So that's why I feel like we might be making some headway, at least with them starting to trust him. But, teenage boys don't want to talk about their feelings, let alone. But I think having a man for some reason has helped them because it's all been women before Dr. Haskins. And he's been doing this a long time, he said. So I think he may have some tricks in his bag.
If you look at the original divorce agreement, it says that they're supposed to go to counseling.
You're breaking up, Mr. McLaughlin. Here's what the court's going to do. The court's going to adopt the recommendation. The court suggests both counsel reach out to Mr. Haskins for reunification counselor. And if he doesn't have any recommendations, then perhaps counsel can figure that out. We're going to put in a review date, and the court's going to interim order that Mr. McLaughlin shall have therapeutic parenting time with family counseling shelter services. So both of you need to do an intake. Mr. Walker, if you're still there, can you add to this recommendation, please? The dad shall have some contact with the children. The court's going to order that dad shall have contact with the children, the therapeutic contact at family counseling shelter services in the interim. We'll set a review date sometime before the holidays. So we need to have some contact between the boys and dad. It's not counseling. It's not counseling. It's just someone observing the interaction between dad and the boys.
If I may, when I took them to Applebee's and I was ordered to a family dinner, you had told me if they didn't get out of the car in 15 minutes, I could leave, and they would not get out of the car. I am willing to take them wherever, but I just don't know what to do at this point. They're both bigger than me. I've grounded them from video games. I'm at this point, I can't ground them from anything else because they don't want to see their dad. I don't know what to do at this point.
You encourage it. Well, these boys are not going to drive the bus, Miss McLaughlin. You have to encourage them, walk them to the door. Otherwise, you sit in the parking lot for 30 minutes and wait until they get out.
And
the court's can order that the dad have
I'm willing to walk them in the door, but if they don't-
services. We'll set this for review in December, about December 23rd, 24th.
It's Christmas.
Okay, we'll set this for a matter for review. December 18th at 9 a.m. Is everyone available?
Yes, Your Honor.
Ms. Churchill?
I've got to grab my schedule, Your Honor. I'm covering for Kim today because she's in an all-day mediation with Mr. Godfrey.
David.
I can't get
Yes.
this one.
No, I won't be available on the 18th. I'm having surgery on the 13th and I'm out for 10 days.
Okay, maybe Ms. Dang, someone from your office can handle this?
Anybody?
I'll find somebody else on.
Otherwise, let's move it to 10th or 11th then. 10th or 11th. I was trying to give some more time to see how this works. But I wanted to schedule before the holiday of Christmas, Mr. Churchill. So let's look at the 10th and 11th of December.
Yeah, 10:30, 11, or 11:50.
Just about, we got some dates here, December 10th.
Can anybody?
10 a.m., 10:30.
10 a.m. or 10:30 on December 10th.
10 a.m.
I can do either, Your Honor.
Mr. Churchill, December 10th, 10 or 10:30.
Okay, we'll have somebody available.
Any preference, whether it's 10 or 10:30?
We can do 10, Your Honor.
10
David.
o'clock's fine.
David.
Yes, Mr.
Right
McLaughlin.
here. I recorded that whole
I know. It's just.
All right, so we're gonna review parenting time December 10th at 10 a.m. via Zoom. In the meantime, court would suggest reach out to Mr. Haskins. Council work to with Mr. Haskins, reach out to him to see if he can recommend the others. Apparently, he did not agree with this one female that Mr. Churchill referenced. Maybe there's another person. And then so until we can move on that, the children shall have therapeutic contact with their father at Family County Shelter Services. So both parties should contact the agency today to schedule that intake. Mr. Walker, can you put in the order the phone number of that agency so they can both immediately contact them? And maybe let's if Mr. and Mrs. McLaughlin, why don't you write down their number? You can call them today. I know that there's a court order for therapeutic parenting time for dad and the boys. And Mr. Walker, we can give you verbally over the phone the phone number for that agency.
Yes.
734 area code.
Yep. 0. Your Honor, I do have a question, if I may.
Yes, Mr. Walker.
As far as the visitation through family and counseling shelter services, is it going to be therapeutic or is it simply supervised? Is my first question.
What do you recommend? I just want there to be somebody to a neutral third party just to see how to provide the court with a report in terms of how the boys reacted with that and how dad interacted with the boys.
At that point, Your Honor, it would just be supervised, I believe, and they'd be able to get in sooner with supervised than therapeutic to begin with.
Okay, we'll do supervised then.
Okay. In addition to that, I was wondering if Your Honor wanted to speak on who's going to pay for intakes and who will pay for the sessions.
Well, each party can pay their own intake and dad will pay for the sessions.
Okay. Thank you, Your Honor.
15 medical.
We'll review this matter on again December 10th at 10 a.m. In the meantime, hopefully Mr. Haskins can continue. The court believe that's important. The boys have a relationship with Mr. Haskins. It's very important that will continue. Hopefully Mr. Haskins can offer some additional suggestions. Okay. In terms of reunification. So we'll review this on December 10th. Yes, Mr. Carson. Mr. Churchill.
Yeah, there were two minor things I wanted to mention too. One, he will not provide her with a copy of the insurance card. I know
Mr. McLaughlin, court's already to provide a copy of the insurance card. Do that today. Make a Xerox copy of it and you send it over to Mr. Churchill and have your attorney fax over to Mr. Churchill.
If I do that, sir, then I'll have absolutely no contact or no anything with my kids. I don't.
Okay, we're talking about insurance card, Mr. McLaughlin.
He has to do is call and let me know where she's going, and I will call and make sure that they have.
It doesn't work.
Well, if mom needs to take them to the emergency room, she should have an insurance card for the children, Mr. McLaughlin. So the court's ordering that we'll add that to the recommendation. You shall, within 24 hours, provide a copy of that insurance card to Mr. Carson so he can provide it to Mr. Churchill. Just make a Xerox copy of it, front and back. Okay, the second issue, Mr. Churchill.
Your Honor, your order of September 26th, and we had filed a motion to compel discovery. There were two cars that were ordered to be sold back on December 15, 2022 in the judgment of divorce. He's provided no information. You ordered them to provide the interrogatory answers within 14 days on September 25th. Just yesterday afternoon, we got handwritten, unnotarized, defective answers, and they came 45 days after they were supposed to be produced. And we're trying to find out what's going on with these two vehicles. All we know is it looks like he sold them to his girlfriend and her son, and she just passed him the other day driving one of these vehicles. It's nothing but game playing here. He's had plenty of time to answer these. Kim's filed, I believe, 2 motions to compel. The court put it in its last order within 14 days. He was to answer these interrogatories. And I get handwritten, 2 pages of handwritten stuff with some other documents behind it, which are pictures of the car and the repairs he had to make and things like that. I don't know what we have to do to get these answered, but they have not been answered. We've been jerked around on it, and to get a handwritten document like this, it doesn't even have a caption on it, no notary, nothing. They've not been answered in accordance with the court rules, and what they did provide was over a month after the deadline you gave them on the second motion to compel.
And Your Honor, let me just say this issue, there's no order to show cause regarding these interrogatories or the request for production. There's not even a pending motion regarding the car, and pursuant to MCR 2.301A4, there has to be a pending motion to open discovery. There is no pending motion. This is not before the court today. There was request for production. We
Hold on,
gave them
Mr. Carson,
everything that
hold on. There was a motion to compel discovery heard by this court on September 24th.
No, I understand, but
the court
it's
ordered
not
that he
be-
do that. So this court will do it a show cause against Mr. McLaughlin on that December date. So if he's not provided the information, the court will address and commence contempt proceedings. So we'll add this recommendation. The court's not going to play games here. Not going to come back to court and separate issues on separate days. And Mr. McLaughlin was ordered to provide discovery answers to his attorney on September 24th, 2024, who's going to provide that to Ms. Kuhn within 14 days. Has not been done. So we're going to start show cause proceedings on December 10th at 10 a.m. So Mr. McLaughlin, Mr. Carson, get it together and get that information in signed notarized form to Mr. Churchill.
Understood. And then, Your Honor,
that's a recommendation.
I guess there is some more issues then if we're going to do that. So the
We're
court has
dealing
ordered.
with two in the last order. We're not going into all this other stuff. These two were addressed.
We're going to do it. I'm going to do it. Your Honor.
You today.
Your Honor. So mom was ordered to place various activities in the app close calendar for the children, soccer games, stuff like that. She has not complied with that court order. She is not communicating with dad about medical issues, and she also switched the children's soccer team without consulting with father. So we also asked that a show
cause as the mother for not complying with the order of this court of September 10th that all activities be added to the app close calendar. We'll do show causes to both parents. Maybe you can both spend Thanksgiving together in jail. So this shows both parties. Mr. McLaughlin, you need to get your acts together and communicate.
Judge, the
We'll add that to the record. The order this morning show causes to both parties. Mr. McLaughlin's failure to answer the interrogatories. Ms. McLaughlin's alleged failure to add to the app close calendar all activities regarding the children. And that will conclude this hearing with everyone on December 10th at 10 a.m.
Thank you. Have a good day.
Nothing to put in there.
Okay, very well. Thank you, Your Honor.
Welcome. For the record, this matter is before the court for the purpose of reviewing parenting time. This hearing is being conducted via Zoom. Present is Attorney David Carson, representing the plaintiff father, William McLaughlin. Ms. McLaughlin appears to be present with Mr. Carson. In addition, Attorney Timothy Churchill is present, representing the defendant mother, Misty McLaughlin. Ms. McLaughlin appears to be present with Mr. Churchill. Good morning, everyone.
Morning, Your Honor.
The parties have conferred with Mr. Walker for the front of the court this morning. Mr. Walker's recommendation is as follows. Mr. Haskins, the therapist for the children, has not and will not provide a list of reunification counselors at this time. The parties and the minor children are on a list at Downriver Family Connections and Wyandotte for supervised parenting time. There has not been a supervised visit yet. Supervised visitation at Downriver Family Connection shall continue, and they should provide written reports to the front of the court regarding supervised visitation once the visitation commences. And further, that the parties appear back for this court to review any outstanding issues, particularly parenting time, for plaintiff father on February 25, 2025 at 9:30 a.m. via Zoom. That is a recommendation. Apparently, the court's informed that Family Counseling and Shelter Services will not supervise dad's parenting time. So as an alternative, we are going to explore parenting time, supervised parenting time for dad at the Downriver Family Connections. Is that correct, Mr.
Correct.
Carson?
That is correct, Your Honor.
Do the parties both, I guess we need a phone number. Do both parties need to contact the agency to schedule an intake? Does anyone have that phone number?
Yes.
They have that, and they're both on the list to be scheduled for the intake.
Oh, good. Oh, wait, was there any idea of the time frame for the waiting list?
They said after the holidays.
They said it will most likely be after the holidays because of how busy they are
Short work weeks.
and short work weeks.
Well, I can understand that for the week of December 23rd, but hopefully they can schedule some the week of December 16th, the next week. So the court encouraged both parties to call and try to see whether they can make it. If there are any availability, the court would order that the parties cooperate. Obviously, the court wants to reunify, have spent some time with his children as soon as possible. So Mr. McLaughlin, call the agency, see whether they can squeeze something in between now and the end of the year. And if so, then Mr. Carson can call Mr. Churchill, and Mr. Churchill, the court would expect Mr. McLaughlin would comply with that opening, availability, and transport the children. With respect to the prior order that Mr. Haskins was to provide a list of reunification counselors, the court is informed that Mr. Haskins does not believe reunification is appropriate at this time, but he still sees the boys on a weekly basis. Is that correct?
Correct.
For that reason, he would not provide a list of reunification counselors. Mr. Carson, is this recommendation good with your client this morning?
Yes, Your Honor.
Mr. Churchill, is this recommendation good with your client this morning?
Yes, Your Honor, and the issues we just talked about. We have a few other issues too that aren't addressed in there, so.
Okay, one issue, I do note that a motion for finding contempt was filed. I don't know if that was noticed up for today. It had to do with the insurance card that for the children that was not provided within 24 hours. Is that one of the issues that needs to be addressed?
Yes, that is one we need to address.
Okay.
On,
when did your client
if you want to
ultimately
address
receive
it
that?
now, we'll do it
Yes.
one at a time.
When did your client receive that card, Mr. Churchill?
My client received the card on Friday, right, the December 6th, right after I sent the motion to his counsel to hold him in contempt for not providing it in 24 hours. You were pretty specific when you told him that. And we got a health insurance card, but there's no information on there about the dental coverage they had or the vision coverage, which was through another company. And again, we were in court November 12th. You were pretty clear when he had to produce that. And this is just reflective of how he cooperates in regard to any issues.
All right, Mr. Carson.
Yes, Your Honor. So I did not, just for the record, I did not receive the contempt motion in the mail until Monday. So I didn't even know there was a motion filed. There was no notice of hearing with the motion. So there was no response filed. But however, my client was very hesitant to provide the card because there's been some past history of Ms. McLaughlin contacting my client's employer, and she would know where my client worked if she did receive that card. However, after talking with my client, he did give me the copy of the card. It has been provided to Ms. Kuhn. So I believe that that Ms. McLaughlin does have a copy of the card right now.
Mr. McLaughlin was ordered to provide that to you as his attorney within 24 hours. Did he do so?
Yes, Your Honor.
Okay, so you failed to pass it on to Mr. Churchill and Ms. Kuhn. Is that the situation?
Well, there was, he did provide the card to me. However, he was very reluctant to have me send the card for the reasons that I previously stated, Your Honor.
Okay, but what did this court enter an order on November 12th that father was to provide his insurance card to his attorney within 24 hours?
Yes.
Okay, so he did provide that to you, but you failed to forward it to Mr. Churchill and Ms. Kuhn. Is that correct?
That is correct.
Did you communicate with Ms. Kuhn and Mr. Churchill advising of the concerns?
No.
All right. Okay, so obviously it was not provided within 24 hours. It was ultimately provided. Do you have all the insurance cards, Mr. Churchill, now? Do you have the insurance card for?
We have nothing on dental and nothing on vision. We have the regular insurance card.
Okay. What about them, Mr. Carson? Are there different insurance companies, or does that one card cover?
Yeah, it's a different company.
And dental?
So, Your Honor, my client did start a new job. He has not received any dental or vision insurance cards yet. When he receives them, they will be provided as soon as he gets them.
When he received those, is it within what 60 or 90 days of his new employment?
I have no idea. I don't believe my client knows, but like I said, he has not received them. He is going to look into it, so we are not withholding anything, Your Honor.
Well, again, obviously, unless we establish a time frame, it'll never be received. Mr. McLaughlin should know when his benefits begin. He has no idea. He's never been inquired what he's got when he has dental or optical insurance.
Benefits have begun. I just haven't received the card in the mail yet.
I don't know if you heard him, but he said the benefits have begun, but he's not received the card in the mail yet.
Okay.
He's with the same employer, Your Honor, and he's got the health card. I'm sure he's got the other cards too. And there was no explanation stating, hey, there's other cards forthcoming or anything. He just doesn't cooperate. And when he does,
I'm going to give him the health
it's
insurance.
months later and partial compliance.
Your Honor, the medical card was provided. He has no problem. I've had many conversations with my client about providing this information. There's no problems going forward. He does not have it. When he has it, he will provide it. So let him at least go speak with the HR person at his new job that when did you start it?
July.
In July.
End of July.
End of July. And he will get a copy of it and provide it. But he
Okay,
does
so
not have it, so he cannot provide it.
Well, but he should call. He should call in and get that card. Obviously, I mean, if he started this new job in July, he should have them by now. But then if he's not, he should call them. So the court wants to establish a date by which he'll provide those cards to Attorney Kuhn or Churchill. Well, what day can he should call the HR department today and tell him he needs those cards. He needs dental work. I mean, the mom should have that for the children. I don't know when the children last had a dental appointment. So, Mr. Carson, when can we? Let's put in this recommendation a date for which you'll provide the optical and dental insurance cards.
30 days, Your Honor.
How about by the end of the year?
Okay.
I'll try.
Yeah, we'll do our
Happen.
best.
Mr. Walker, if we can add this recommendation that the plaintiff will provide to mother through his attorney the optical and dental insurance cards for the children prior to December 31st, 2024. Mr. Churchill, the court recognizes there was obviously a delay. Mr. McLaughlin apparently complied with the order. He provided his attorney with the card, but then the attorney did not provide that to you. Did the children, was there any healthcare services rendered that were not covered by insurance because of the fact that Ms. McLaughlin had not received that card by December 6th?
Yes.
Yes.
Okay. What does she have documentation of those medical appointments?
She has prescriptions out of pocket she had to pay for, and this is what she always does. And then she sends her the bill, and he never pays her back for what he's supposed to pay.
Your Honor, I'm sure there's a copay. My client has been in contact with the pharmacy and the children's doctors. There's no outstanding medical bills. And if there is a copay, that should be covered by the ordinary medical. So
not when you don't have a card and you can't tell them who.
Mr. Churchill, hold on. Mr. Churchill, let Mr. Carson finish, please.
I have to see some documentation, Your Honor, but according to my client, everything has been covered.
There is outstanding bills.
There's outstanding bills.
All right, the court will reserve, and we can address on February 25. The court will address any unpaid medical expenses. So Mr. Churchill will provide documentation to Mr. Carson and to the front of the court, and we can address on February 25 if there's not covered by ordinary medical. And again, the court's going to order that the plaintiff father provide to defendant mother's attorney the vision and the optical and dental coverage cards prior to December 31st, 2024. So that will address that issue. And if in fact there was a out-of-pocket cost that was unnecessarily incurred, we can address that on February 25, Mr. Churchill. What other issues, Mr. Churchill, do we need to address today?
Well, and again, I just want to state on the card, Your Honor, your order further said that he shall provide our office a copy of the card when it's received. So he elected to sit on it for almost a month before we got it. And again, that motion was emailed to him on Friday. Within hours, we finally got a copy of the card. I'm just livid. He never does what he's supposed to do, and his attorney doesn't do what he's supposed to do. The other issues deal with the discovery that we sent him back in August and September, which we finally got answered on December 9th. And of course, the answers were a joke. They're incomplete. And we'll get into the sale of these cars. He was supposed to put these cars up for sale on January 1 of 23. Here we are 2 years later, and he claims he sold the vehicles, the Focus, the 2012 Focus, for $500 and $2,000. And the person he sold it to was Sarah Lang, who's his girlfriend, and a Robert Badilla, who's his girlfriend's son. Same thing with the other car. Oh, he sold them back in May of 2023 and sold them both for a loss to his girlfriend. There's no evidence title's been transferred or anything here. It's just a
Mr.
joke.
Churchill, you can notice those up. Once you notice those up for hearing on February 25, 9:30, let's deal. If there's some post-judgment property issues, notice those up for hearing. We'll address those on February 25, 9:30. We're coming back to address parenting time.
Okay, well, if I can at least address the discovery answers that were due months ago, ordered to produce them by the 12th of November before, ordered to produce them again. We finally got them December 9th. We got them a day before the hearing.
Okay.
They were due months ago, ordered to be produced on a motion to compel. We filed 2 motions to compel. His attorney never timely answered those either.
We've now received them. Even though they're late, we've now received them. Is that correct?
We never received them. He was ordered to produce them by the last hearing on November 12th. He didn't do that.
Your Honor,
we waited another month.
Your Honor, first up, Mr. Churchill's comments are highly offensive. I want to share my screen and share the email that I received from Kim. There was no motion attached to it, so if the court would like to go into that, we can. I received the motion on Monday in the mail only. And if you look at the order, it says nothing about a due date for the discovery. They've been provided, they have been satisfactorily complied with. I have no idea what Mr. Churchill is talking about. He just makes these wild statements without any specificity at all. So this is completely ridiculous, completely offensive. Mr. Churchill is not being professional in the least. And also, there is another issue about the F-close calendar that's still not being followed. She lied to Mr. Walker during the hearing with friend of the court. And we have pictures, we have a roster to show that the son is in soccer. He played in the game. We have picture of it. So if we're gonna go into all of this, then I guess we have to go into the soccer stuff too. But this is completely ridiculous, Your Honor.
Okay. Well, the court just will reemphasize the parties must use app close. And obviously, if they're going to hear you now, then people are going to print out those app close communications. The court will take action. But let's just, Mr. McLaughlin, all communication via app close, please. As previously ordered, the court will once again reemphasize all communication shall be via app close and regarding the children. With respect to discovery, Mr. Churchill, you're saying the discovery is incomplete. Is that correct?
Well, Your Honor, I want to point out, I just need to address what he said. Your order on September 24th said Mr. McLaughlin shall provide discovery answers to his attorney who will provide that information to Mrs. Kuhn within 14 days. That's what we finally received on December 9th, what he was supposed to do back in September. And to refresh opposing counsel's recollection, there was also a motion for sanctions filed in October on this issue about you not timely answering discovery. And I'm not imagining this. I have a stamped copy of it from the court.
Your Honor, I'm looking at the last order dated November 12th. There is no due date. It says the show cause proceeding regarding discovery and defendant's failure to add items to the shared app close calendar shall be heard December 10th, 2024. So they filed a motion to compel. Allegedly, it was not complied with. So there's a show cause hearing on the matter. Discovery answers were provided. Mr. Churchill is being extremely petty. He has some hostility toward me and my client. He has the answers. He has everything that he needs, Your Honor. This is a waste of time.
Okay, has discovery now been completed? Even though it's been late, Mr. Churchill, have you now received the requested discovery?
Finally, months later, if you look at the court's order on September 12th or September 24th, it specifically states Mr. McLaughlin shall provide the discovery answers to Ms. Kuhn within 14 days. That was back in September. Then there's a court order in here that you signed on September 12th in that regard. I don't know what the...
Have you now received the discovery?
Finally, months later, and after having to file motions to compel, we shouldn't have had to file. And then we find out he's never sold the vehicles.
Your Honor.
Well, that's duly noted that the discovery was late. Was there a motion to compel that was filed, Mr. Churchill?
Yes, there was. There was also a motion for sanctions that Kim filed that's clocked in.
Okay, what are you asking for, Mr. Churchill? What's your request?
July 29th, attorney fees for having to repeatedly file motions and make requests for documents that should have been provided a long time ago. Kim provided a statement in the court file for $470 back in October, and we're still coming back on this
Your Honor,
issue.
Respectfully, the court already ruled on that. There's been an order entered since the September order. So if someone doesn't comply with an order, you show cause them and ask for sanctions then. So today's the show cause.
You know,
discovery has been
continue to give you additional time to do it.
Your client is not complying with the order either. Do we really want to get into this?
My client complied with the order. Your client got an app close message.
She did not.
You took months to get this stuff out. Just like you get the insurance card and the court tells you to give it to us and you decide to sit on it. All I'm asking for is cooperation here. Jeez.
Your Honor, he has everything he needs. He's being extremely petty. He wants to waste the court's time. He wants to run up his client's attorney fees. He is extremely unprofessional. He's extremely insulting. This is completely ridiculous, Your Honor.
Mr.
You are extremely non-compliant.
Mr. Churchill, before your office filed the motion for finding of contempt for failure to provide the insurance card, did you communicate with Mr. Carson asking where's the insurance card? Was there any communication, email or letter?
Your Honor, can I share my screen?
I'm just simply asking, obviously, Mr. Carson already stated that you did not provide it once you received from your client. I'm just asking, did you receive a demand, a request from Ms. Kuhn or Mr. Churchill for that insurance card before they filed the motion?
I received an email on December 3rd stating, please have your client contact Downriver Family Connections, and it says the phone number to set up an intake for supervised visitation. I also want to remind you that we never received the insurance card that your client was supposed to provide. When can we expect it? It was sent to her on Monday, December 6th. So there was no motion attached to the email, as Mr. Churchill has falsely stated already. So
December 6th was a Friday. When was the email?
So I got the email December 3rd, and then I sent everything.
Tuesday.
Yeah, sorry. So I sent everything on December 6th. They've had a copy of the card since December 6th. I've already addressed it with the court, so I'm not going to restate what I already said.
Right. Did you respond on December 3rd or December 4th?
No, I responded on December 2nd. It said, please see attached. And I have a copy of the.
Okay, well, again, in the meantime, Ms. Kuhn, because she didn't hear from you, filed a motion to find contempt dated for December 5, 2024. And that should not have been necessary had you promptly responded, Mr. Carson. I understand you've got a lot going on, a lot of emails, but that should have been, they should not have had to file that motion. So the court will order that Ms. McLaughlin pay $300 in attorney fees to attorneys Kuhn and Churchill. That $300 shall be paid on or before December 31st, 2024. If you can add that to the recommendation, Mr. Walker.
Your Honor, what's that $300 based on?
It's based upon that attorney, and I'm sure they billed their client more than $300. Ms. Kuhn filed a motion for finding of contempt for failure to provide the insurance card. And that was dated December 5, 2024. That would have been unnecessary had you timely responded to the email asking where the insurance card was.
Your Honor, I responded 3 days later. I would say that's timely. I'm not at my desk all the time. I don't have time to sit here and respond to emails every second they come in. They're provided 3 days later.
They should have been provided within 24 hours as the court says, contrary to this court's order of September 12th, 2024. So that is ordered to be paid on for December 31st. We'll review parenting time on February 25 at 9:30.
Your Honor.
And parties shall use app close for all communication. We'll reemphasize that.
Your Honor, there's supposed to be a show cause hearing regarding Ms. McLaughlin's failure to provide dates on the app close calendar. So you're going to sanction my client, but we're just going to ignore her violation?
All right. Okay. What I would have to, I was not, hold on. I was not aware there's a show cause hearing separate today on the app close.
There is.
Okay. Okay. And it's your position that, how much you're requesting, Mr. Carson?
We're going to request $500, Your Honor.
For what?
Tax from
For the motion?
For communications, attending these hearings, all of that, Your Honor.
Did you file a motion for her to show cause alleging violation of the app close communication?
Your Honor, I don't understand why I have to file a motion if the order already states that the show cause proceeding is going to happen on this day, Your Honor.
Did your client incur unnecessary attorney fees because of that alleged failure?
Yes, Your Honor. I keep having to appear at these hearings and address these outstanding issues.
Right. All right. So Ms. McLaughlin shall pay $300 to Mr. McLaughlin on before December 31st. Each can pay each other $300. And that will address and resolve those issues. And the quote puts back on docket February 25, 9:30 a.m. Mr. McLaughlin, communicate.
Your Honor,
it's creating a lot of unnecessary expense and issues for your children.
Your Honor, in light of
can you add a couple of those two things, Mr. Walker? That will conclude this hearing. The copies will be mailed out to counsel.
Your Honor, just real quick, in light of the offsetting attorney fees, can we just agree not to pay each other? It's just a waste of time.
He didn't
I'll
order
get to you,
her.
Mr. Churchill.
Your Honor, I thought you said Mr. McLaughlin did pay to Mrs. She has
Correct.
the app closed.
Each will pay $300 to the other for attorney fees unnecessarily incurred. If you want to zero it out, I'll leave that to counsel.
Yes.
Okay, well, I'm asking the court, did you order her to pay him attorney fees? I don't think you did, so there's nothing to offset.
Yes, I just did. Each will pay the other attorney $300 before December 31st.
Here's a text from Coach Johnny that says.
I have the
I'll
app
include this
closed
matter.
message.
Everyone zoom out.
Oh, Jesus. Okay.
For the record, this matter is before the court on a friend of the court initiated show cause directed to the plaintiff. The friend of the court asked that the matter be placed on this court's docket rather than before the front of the court referee. This hearing is being conducted via Zoom. President Attorney Stephen Rotenberg representing the plaintiff, Erica Carter. Ms. Carter is present. Excuse me. In addition, the father, Bobby Carter III, is also present. Good afternoon, everyone.
Good afternoon,
Judge.
Mr. Rotenberg, the court notes in the file you have filed a motion on behalf of Ms. Carter to modify custody. That hearing is a motion not before the court this afternoon. Is that correct?
That is correct. However, and Mr. Carter can agree with me or not. I believe that he said to the, and this is under MRE 408. So I know the court's going to hear it, but the court can ignore it if it chooses so, that he's agreed to allow the children to remain in Bedford, remain where they are right now, so they can be in Bedford schools to not interrupt their school or athletics. Is that correct, Mr. Carter? Hello?
I was addressing the judge. I didn't realize I was supposed to be addressing you.
Okay, yeah, no, if that's correct, we're just trying to streamline it. If we don't have to do that second, our motion.
I'm not streamlining anything. I want the judge to go through the proceeding the proper way.
Okay,
Sorry.
that's fine. All right, I thought we had an agreement, so that's why I asked you. All right, we do not have an agreement, But our motion for change of custody is not on for today. The friend of the court's motion to show cause is.
Okay, all right, thank you, Mr. Rumberg.
Could we swear in the parties, please?
Yes, one moment, please. The allegation is that Ms. Carter has denied parenting time to the defendant father. The court would also just note for the record that there was referee recommend order dated June 13th, 2024. There was no objections filed to that. And that order denied mother's motion to modify parenting, modify custody, but she can always, of course, file another motion, which her attorney has done. It also directed that the children remain enrolled in Monroe Public Schools, now stating the fact that mother apparently has allegedly changed them to Bedford schools without the consent of the defendant or the court. In any event, the parties have conferred this afternoon with Ms. Patrick from the front of the court. The court find recommendation that the plaintiff mother be held in contempt for violating the parenting time order since June 13, 24 until the current date. The children shall remain at Bedford School District at this time. Father shall sign up the minor children for counseling. That is the recommendation. Mr. Rodenberg, before I ask whether or not your client's agree with this, you want the party sworn, is that correct?
Yes, Judge, just in case we have to go on the record with anything.
All right, to Ms. Carter. Ms. Carter, can you both raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Yes.
Thank you. Mr. Carter, I'm going to start with you, Mr. Carter. Do you understand the recommendation this afternoon? And do you have any objection to the court adopting it?
So I'll start off by saying that I do agree with my children staying in Bedford schools, just because I don't want to confuse them with athletics and with them already enrolled in the school. And I do want them to actually go to a better school. And I've been trying, which Miss Carter will say, we've been trying to get them in the school of choice. And I do really like Bedford schools. The purpose of the motion is that nothing's been followed by your recommendations, where Mrs. Carter's constantly overseeing the fact that we're joint custody, physical and legal, and that every time that she makes a decision based upon her, whenever she makes a decision, it's her decision. And then she just tells me this is what's going to happen. And I just need her to be put in check, not by myself, but by the court, saying she doesn't have any rights to do anything unless we both agree upon it, which is what I'm trying to establish today. And also with the recommendation of my child parenting time, me and Mrs. Carter have been in an agreement to allow and resolve where she's actually.
Okay, so Mr. Carter, you agree it's in your children's best interest to change from Monroe to Bedford schools?
Yes, sir.
And remain where they are, okay? And where do you live? Can you still exercise your parenting time?
So
that's a longer drive?
Changed a lot with the parenting time, and that's another thing that it's almost like a malicious intent, because now I don't have I can only see my kids 2 days a week versus the established 3-4 because of my schedule. And every time that I've had a schedule change, me and Mr. Carter's come up with new agreements for our parenting time, and every single time it's just became an issue. So that's I try to comply a lot with her, and I try to converse a lot with her, and I try to go above and beyond to do anything I can to help with the situation, saying, hey, this is how it is. My life's not as easy and as simple as hers, where she goes to school. I have a lot of schedule changes to my job. And I've even gotten a new job recently where I've quit my old job just so I can have a job where I've established the weekend time so I can see my kids on Friday, Saturday, and Sunday, which is what she wanted. So I complied again. And with the court time, we've established that we're trying to work on me allowing me to see my kids and make up back time. So then I don't want her to be in contempt of court. I don't want her to be fined. I don't want her to have to go to jail, because that's going to do nothing but cause more trouble for our children. And then today I got blindsided by her having an attorney and her trying to, again, take physical custody of my children, where the last case, she didn't even show up for the court hearing. So it's,
that's not the issue of custody, not before the court today. And you're exactly right. Joint legal and joint custody, legal custody means you share equally any major decision concerning the welfare of the child, your children, especially school. Just because you had the school, that's got to be the agreement between two of you. And there's no question a change of school can affect parenting time. That's why I want to make sure that you're agreeable with this change of school to Bedford. And you believe it's in your children's best interest to go to Bedford, but even though that may change parenting time. Do you understand that? You need to answer in the affirmative or negative?
Yes, sir. Affirmative.
Okay. So you're asking the court to adopt this recommendation that the children continue in Bedford school? Can you acknowledge?
Yeah. Oh, sorry. Yes, sir. I don't know.
Okay,
If my mic.
You understand this may very well change your parenting time schedule.
Yes, sir.
Okay.
So that's another thing that I've established with Mrs. Carter is that I can still keep with the same current parenting schedule of Wednesday, Friday, Saturday, Sunday, and then Wednesday, Friday, or Friday, Saturday, Sunday, and then the following week, Wednesday, Friday, Saturday, and Sunday. And Mrs. Carter has made it an issue with me because she doesn't want me to. It's going to affect the bus times and all this. Like there's so much stuff that goes into this that it's really she just keeps putting me in a position where she changed the schools, she enrolled them in sports, and now they're already enrolled in the school, and now we have this court.
Understand, Mr. Carter, if you're agreeable to it, let's not keep beating the dead horse. If you're
Right,
agreeable
right.
to it, there's no question. She was wrong. She has no authority to unilaterally change schools without your consent or the court's consent. She has absolutely no authority. We'll make that real clear to Ms. Carter. But you're agreeable to it, so let's not keep going there, okay?
Right.
And have you agreed upon a modified parenting time schedule? Do you need to talk with friend of the court today about modifying your parenting time schedule? Do you want to come back at a later date to do that?
I would want to. We already have an agreement where it's 3-4-3-4. So as long as we can keep that, that would be fine. The only thing that I would modify would be the child support amount in itself. That would be the only thing, because me changing my new job, now I'm making significant less money, and as well as I have to pay for insurance as well. So when I was at my previous job, I was paying $300 a week, plus I was paying an additional $180 a week for insurance because I have to keep insurance on the children. So when I go to this new job, everything that me and Mr. Carter agree upon, it gets changed, or she wants it her way. So I would just want to establish a agreement between me and her today of what would work best for both of us.
Well, you need to file a motion to modify child support if you want to modify child support, but
Okay.
until further order, your parent time remain the same. So you have week 1, Wednesdays at 4 to school on Thursday mornings, Fridays at 4 to school on Monday mornings. Week 2, Wednesday at 4 o'clock to school on Thursday morning, and then Saturday 9 a.m. to school on Monday morning. That will continue until further order.
Correct.
Okay. All right. So you're asking the court to adopt this recommendation. Then is that correct, Mr. Carter?
Yes.
All right, Mr. Roenberg, your client's position on this recommendation?
I believe, at least for 2 of the parts of it, that she'd agree to it. As for the contempt portion, of course, I don't think anybody would ever agree to that, and we have an explanation for some of it. Okay, so there's two of the older children are really the ones I believe that Mr. Carter is complaining about the lack of parenting time with. There's the daughter Leah, and there was apparently some kind of a CPS investigation going on. So apparently Leah said that inappropriate comments were made to her by Mr. Carter, and she was worried about it. And as for Bentley, the 12-year-old, he claimed that he was thrown against the wall or some such kind of domestic violence against him. And again, I'm playing broken telephone here with this.
All right, so Mr. Roenberg, if
this
Mr.
gets
Carter,
to their preference.
Mr. Roenberg, if your client wants to deny parenting time, she's got to file a motion. She can't unilaterally just deny parenting time. She's got to file a motion and ask the court for an order restricting parenting time.
Well, going forward, we will do that. Now, I would also like the court to recognize that Mr. Carter has our extreme gratitude for his act of grace by agreeing to those bits of the recommendation that he did to, and he has our appreciation and gratitude because for a number of things. So what we would like to do is, if we can, going forward, reduce the temperature of this case a little bit, because I think it is reducible. If we don't disagree with the children going to counseling, I don't know what was going on with the violence or lack thereof. I'm just reporting what I was told. As for the counseling, perhaps that's a good idea, and I don't object to it. We'll have to figure out how this is going to go about or whatever. Now, as for Ms. Carter missing that hearing back in May, she's at nursing school, and she also has 2 jobs as a server in Toledo.
That's fine.
She's not there, but hang on.
The order was entered because she failed to appear, so that's
right.
I don't need any explanation why she failed to appear.
But she didn't appear. She didn't appear because she had a clinical rotation that day, and she could not appear.
Not a problem. Not a problem, Mr. Roenberg. Not a problem at all. The orders. There's been no objection to it. Not a problem. She didn't participate. Not a problem. So the children, Dad will set up the children for counseling. The children were made in Bedford schools. Now, is Ms. Carter going to comply with the parenting time order of this court? That's the question. I mean, all 4 children, not just the children that she wants to send to dad for parenting time. All 4 children. Will they be? Dad's been denied parenting time since what? June 13th.
I've instructed her.
Comply with the order going forward.
I've instructed her to comply with it and tell the children that the court orders to be obeyed.
Do you understand that, Ms.
it's not-
Carter?
Yes, I do. I left it up to them what they wanted to do.
No,
The
ma'am,
older
Ms. Carter, stop right there. They're minors. It's not up to them. It's between you and dad and the court. If the two of you cannot agree, then you're gonna have the court of stranger decide what's best for your children. It's not up to you. I'm sorry, it's not up to the children. You don't ask them whether they want to see their dad. They have to see their dad. They have a right to see their dad. Their dad has a right to see them. So the court wants to make sure that you understand the pending time orders. Until it's changed, you must comply with this court order.
Yes, I do.
So when are we gonna, we're gonna pick up and drop off the children?
Sir,
You have to get them up to school?
If I can interject, so we've already had established a pickup and drop off time as well. And also
where?
We've established a pickup and drop off time at the courthouse as well as on,
Okay,
on
well,
the
this got to be in writing. You can't have verbal agreements. So Ms. Patrick, can you talk with the parties and see whether or not if they modified pending time? I don't quite understand, or obviously they've obviously pickups, drop offs are at school. So if they're meeting at the courthouse now, I don't know if the times have changed. So if you can meet with the parties and see whether if we need to reduce this to writing and revise the pending time schedule, let's do it today.
Yes, Your Honor.
I'd be in favor of that, Judge. We really need to regulate
Okay, I'll
this.
put you in the back in the breakout room.
Thank you.
Okay.
Recalling the matter of Eric Carter versus Bobby Carter.
For the record, the parties have returned after having discussed parenting time with Ms. Patrick in front of the court, at least on a temporary basis. So the court has received the revised recommendation, Mr. Rolenberg and Mr. and Mrs. Carter. Since Mr. Carter is not asking the court to hold Ms. Carter in contempt of court, that language, that recommendation has been stricken from this recommendation. And Ms. Carter, I'd urge you to cooperate with the father of your children. Because if the two of you cannot agree on things, you need to petition the court. You can't unilaterally just make decisions. Whenever you take the children to the doctors, he should be informed. He should be listed as emergency contact with Bedford schools.
I understand, Your Honor.
So if you have not done that, you do that this week.
Mm-hmm.
Time the children go to the doctors, the dentist, you need to inform him of that. That's what joint legal custody means. So the recommendation is that the children can remain in Bedford School District at this time. Defendant father signed the children up for counseling, so the children shall attend counseling. The parties will meet at the Bedford Fire Station for all parenting time exchanges, and father shall have parenting time every weekend from Friday at 5:30 until Monday at 7 a.m. That is the recommendation. Mr. Carter, do you understand the recommendation as revised?
Yes, sir.
Are you agreeable with this?
Yes, sir.
All right, Mr. Roenberg, is Ms. Carter agreeable with this recommendation as well?
I believe so, yes.
Okay. All right, obviously, Ms. Carter did participate in the discussions. If she had an objection, she would have made that known to her attorney. So the court will adopt the recommendation, copy mailed out to everyone. Mr. Roenberg, I'm not sure if you're still going to come before the court in your motion to modify custody.
No, there's no need for it. We can vacate it. And Mr. Carter, again, thank you for your cooperation.
Right, Ms. Patrick, why don't we then put in this order that the plaintiff is withdrawing her motion to modify custody?
I can do that, Your Honor.
Is there a hearing date on that? If there's been a hearing date?
There is, but I believe it's the 20th. I'm not certain. I have to send it to serve it on Mr. Carter, but that's obviously not going to happen at this point.
All right.
So
if there's been a hearing date to put out there, that will be vacated, and the plaintiff's motion to modify custody is withdrawn. We'll put that in this order. All right, that concludes here, and everyone can zoom out. Have a good rest of the day, everyone.
Thank you, Your Honor.
Thank you, Judge. And again, thank you, Mr. Carter. We appreciate your cooperation.
Thank you, Your Honor.
You're welcome.
Have a good day, sir. Thank you.
Because he never responded to her.
Okay.
So it's not
Gonna do Ron Bruce, or who do we do first?
you just went with
No, he's late. Let's do then if Christina's ready.
No, Clark's already, but we had to wait for Ron Bruce because he was 15
Right,
minutes late.
right. But is
They're not ready.
Wyatt's not ready?
No.
Okay. Okay. The record, this matter is before the court for entry of a proposed consent judgment of divorce. This hearing is being conducted via Zoom. President Attorney Ron Bruce, representing the plaintiff, Michelle Clark. Ms. Clark is present, as is the defendant James Clark. Good afternoon, everyone.
Good afternoon, Judge.
Mr. Clark, you have to unmute yourself.
It should be on the bottom left of the screen.
See the red line? You need to delete that red line.
Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Delete that red line. Del
Ms. Clark, I don't know if you can text them and get there. Okay, there. Mr. Clark, can you hear the court?
Yes.
Okay, all right. Well, we've called the case of Michelle Clark versus James Clark. This matter is before the court for entry of a proposed consent judgment of divorce. Mr. and Ms. Clark, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. Mr. Bruce, you can begin with Ms. Clark, please.
Ms. Clark, you recall contacting my office and having a complaint for divorce filed in this case?
Yes.
And at that time, you lived in Monroe County for 10 days, stayed in Michigan for 6 months, correct?
Yes.
No minor children born of the marriage, correct?
No. No.
And and you're not currently pregnant, correct?
No.
And would you state that there's been a breakdown of the marriage such that the objects of matrimony have been destroyed and there remains no reasonable likelihood that your marriage can be preserved?
Yes.
And if the judge weren't to grant you a divorce today, would you reconcile and get back together with Mr. Clark?
No.
And you had my office prepare a judgment of divorce in this case, correct?
Yes.
And you understand all the terms and conditions, right?
Yes.
And you understand you're not being awarded spousal support, correct?
Correct.
You know you're forever barred, can't come back at a later time and ask for it, correct?
Correct.
And you understand all the terms and conditions contained in the judgment, right?
Yes.
No questions for me on that?
No.
And you're being awarded the marital home, correct?
Yes.
And there's no mortgage on that, and it's currently just titled in your name, correct?
Correct.
And you're asking that your maiden name of Tam, T-A-M, be restored, correct?
Yes.
Nothing else, Judge.
Thank you, Mr. Bruce. Ms. Clark, you stated you're not currently pregnant, but I just want to make sure, were there any children born during your marriage or are still minors?
No.
All right, thank you. Mr. Clark, can you please state your name and current mailing address for the record?
James L. Clark.
Thank you. Mr. Clark, did you hear the testimony of your wife, Michelle, this afternoon?
Yes.
Was her testimony true and accurate to the best of your knowledge?
Yes.
Did you also sign your name to this proposed judgment approving the terms and conditions contained therein?
Yes.
Did you do so freely and voluntarily?
Yes.
Do you have any questions for the court?
I do not.
Do you have any questions for Mr. Bruce?
No, I do not.
Thank you. Mr. Bruce, do you have any questions of Mr. Clark?
No, Judge, thank you.
Very well. The court would like to thank Mr. Bruce for his assistance in helping facilitate ample resolution of this matter, and the court would applaud the two of you for reaching your own agreement. Far better off than have the court decide these matters. Based, however, on the testimony that's been presented this afternoon, as well as the complaint filed in this case, the court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there appears to be no reasonable likelihood that the marriage can be preserved. Mr. Bruce, the court says noting that don't we still have to wait for the 60 days to expire before they can enter the judgment? The complaint was filed August 5.
Correct, Judge. We'd ask the court to consider waiving that.
All right, so 60 days not expired until October 5. So on October 5, the court will sign the judgment, and at that time, the court will order that the marriage between the parties be dissolved and judgment shall enter granting divorce and bonds of matrimony. The court does not believe it can waive the 60-day time frame, Mr. Bruce. So we'll put this back in our on base and wait till the first business day after October 5. That'll be October 7th. The court will sign the judgment October 7th. All right, good luck to you, Mr. Clark. That will conclude this matter. Good luck to both of you. Thank you, Mr. Bruce.
Sounds good.
Thank you. This matter is before the court on the petitioner's motion to terminate personal protection order, which was entered on February 26, 2024. Both parties are present. You are Jenny Willis, is that correct?
Yes.
Willis. Okay, the two of you have a child in common. You're still married, is that correct?
Yes.
It's in Ms. Willis, you're asking the court to terminate this personal protection order because for a lot of reasons. Your husband's pleaded inpatient treatment.
Yes.
And you want to be opting for your future. That's fine. This PPO does not interfere with your relationship or your marriage at all.
I understand.
This is a bare bone PPO. All it does is prevent Mr. Willis from breaking the law. He shall not assault you or threaten you with physical harm or violence. That's all. And the court treats these very serious. The court does not grant it 1 month and terminate the next month. So it will terminate automatically 1 year from the date it was entered. So this will terminate, if you look at your PPO, it will terminate on February 26, 2025. And all this, you can sleep together, eat together, have more children together. Mr. Wilson simply is prohibited from assaulting you or threatening you with physical harm or violence. That's all.
I understand that. I was just asking if the court could terminate it, just being that it's been 6 months. I feel like the reasons that I had asked for it to be put in place, his actions at the time were as a result of his relapse in the substances and alcohol he was using, and being that he's went to treatment and he's completed as well. It just kind of seemed like this negative cloud looming over us that I feel like the reasons that we got it and resolved, and it hasn't just been 1 month, it's been 6. We had a no contact order for 3 of those months where we were able to focus on ourselves separately and come to those resolutions on our own. And the last 3 months then we were doing the outpatient treatment, not only individually, but together as well.
Well, the court certainly wishes you the best and hoping that relationship is strong. But reading your petition, Mr. Willis, there's no reason for men to physically assault women, leaving bruises. You've attached a number of photographs. You were brutalized. No reason for that. So that's it's not just alcoholism. There's some deep-rooted psychological problems when men assault women in this fashion. So the court's going to deny your request. It just is
Your Honor. Your Honor, can I speak?
This is not a game where we give them out and then take them away. So the court will deny your request to terminate PPO. It does not impair your relationship at all.
Your Honor, that was never proven that I struck her. And later in that police report, it also is stated that I never did strike her, and that was not a result of me. The police report was amended. In addition to this, that PPO was supposed to have been served in a certain amount of time, and it was not served. So according to my lawyer, that PPO is null and void. But I was talking to a police officer a while back, and he said there's an ambiguity to it. So that's why we wanted to take this to court and make sure it was terminated completely. Because from what I understand, it was never served in the first place correctly.
Okay, well, you can rely upon your lawyer if it thinks it's invalid, Mr. Willis. You can rely upon your lawyer, even though it's not been served upon you. But this, all it does prevent you is don't assault her or threaten her.
I understand that, Your Honor. But I would, for one, that's all common knowledge and it's common sense. But when all this went down, she didn't even have any knowledge of all this. And from my understanding, it was never. She never wanted it to be served to me. I was arrested on another matter, and out of the time frame of the PPO being served in the time that it needed to be served to be valid, it was given to me. I never signed for it. I never was served.
When he was released on bond and the no contact order was put in place, that was at the time more meaningful than the PPO was. So I didn't have the PPO served in that manner because I thought that the bond conditions of the no contact order were more than substantial of what the PPO was at that time.
Understood. And of course, that's a different court order, but this is PPO is from this court. This is not just a little push or shove. This was significant assault of conduct. So the court will deny your motion to terminate the PPO. Now we'll conclude this hearing.
I'd like to know where you're getting your reason for that, Your Honor. This was never proven to be anything other
You should have filed an objection to it timely then, Mr. Willis.
I didn't know about it. I didn't know about it. And again, so is it even if it wasn't served to me in the time that it needed to be served, is it even a valid PPO?
Attorney, you said you talked to an attorney, so have your attorney consult with them, and if your attorney feels he can take some action, he can do that.
My attorney says it's not even an issue, but the thing is, when I go and talk to these probation officers, they see it come across as it is, but it's not illegal. It's not a legally valid PPO. So that's what we're trying to clear up.
Okay. All right. Again, just so you can tell your attorney that the court denied the request to terminate it, and if the attorney feels he can take some action, he or she, then then so be it. But at this point in time, this court's going to deny the request to terminate the PPO for the reasons stated. All right. Copy mailed to both of you. Good luck to both of you. I wish you the best in your relationship. I really do.
I'm sorry. What was the reason stated?
This court has the discretion. I don't need to give a reason. The reason that the court entered PPO and not terminated is because this is not just an isolated emotional situation where there's an argument, one pushed the other. This was a significant assault of conduct. There's pictures attached where Ms. Willis has black eyes. I mean,
I understand that, but
it's not just a push. So for that reason, the court's denying it. Now conclude this hearing. So you can both zoom out.
That was never proven to be anything that I did.
Okay. You can file appeal with the Michigan Court of Appeals.
I'll file an appeal.
Okay. Sorry.